It's Stephen Heyer versus Mona Heyer. We're here on an emergency motion that counsel for Mr. Heyer have filed seeking some immediate equitable relief. I'd like to get the appearances for both sides, and then we'll figure out what we're going to be able to cover this afternoon. On behalf of Mr. Heyer.
Bert Levy, Cohen Levy, and this is Mary Williams.
Hello, Ms. Williams. Hello, Mr. Levy.
Will you admit me, Your Honor?
I will.
Thank you.
There you go. And on behalf of Mrs. Heyer.
Yes, Your Honor. Adam Glecklin, I entered a formal limited entry of appearance yesterday.
You did. Thank you for jumping on this with short notice so that I understand what that means. You are at least going to be representing Ms. Heyer in connection with the TRO. It may be more than that, but it's at least that.
Exactly, Your Honor.
Okay, sounds good. So you are fully empowered to work through the TRO, and we'll see where that leads.
Exactly.
Okay. Well, here's what I understand the situation to be. The Heyers have been married for about a decade. There's a prenuptial agreement, the contents of which I'm not familiar with. Over the last half decade or so, Mr. Heyer has become less well. There have been some pretty serious mental health diagnoses, some physical health concerns. He now gets round-the-clock home health, and I believe through probate court, his daughter was given some authority over his affairs, and we are running into a collision between what Mrs. Heyer has been doing with the couple's finances and assets and whatnot, and whether she has adequately consulted with Mr. Heyer, assuming she needed to, with the financial decisions she made, and also a collision between Mr. Heyer's daughter's authority to sign off on things and Mrs. Heyer's alleged exclusion of the daughter from being involved in decisions like the biggest one, selling the residence on Valley Road for over $7 million, and then allegedly telling Mr. Heyer, you got to get out. Not quite sure how that works. If she sold it, then everyone has to get out. But either way, the allegation is that the sale occurred without informing Mr. Heyer. I'm not quite sure how that would work if they're both on the deed, but that's what I'm going to learn about today. And I'm open to hearing from both sides. Understandably, based on the allegations, Mr. Heyer is seeking to have certain things frozen. Whatever happened with the money from that sale, freeze it. Doesn't go anywhere until there can be an accounting. Sounds like there are some very important and potentially financially valuable, but certainly personally valuable items of Mr. Heyer's that he can't find now because of the sale and the emptying of the Valley Road address. So we need to work through that a little bit. And we may just have to put some guardrails in place about who can spend what without the other person's authority as this case trundles along. I don't claim that that's 100% accurate, but that's sort of the framework that I gleaned reading half the story, meaning everything that Mr. Levy and Ms. Williams had to say on behalf of their client. So I'm fully aware, Mr. Glecklin, that I haven't heard the other side, and you're going to share some of that today. And we'll see if there is a conceivable other side that makes some of this sound okay. But I am open to hearing it all. I am going to start with Mr. Levy and his presentation, but I will certainly and necessarily hear from you, Mr. Glecklin, on Mrs. Heyer's side. Is there anything procedural we need to cover first before you dive into he said, she said? Mr. Glecklin.
Yes, Your Honor. Essentially, it's a motion to dismiss that it should be heard before there's any testimony.
Okay.
We're inclined to hear testimony. There are essentially four independent reasons you shouldn't even be hearing anything in this case. OCGA Section 9-5-1, OCGA Section 29-4-21, OCGA Section 29-5-21, the interspousal immunity,
Is this reason 4?
that's reason 4, and there is a fundamental failure to state a claim. Georgia doesn't recognize a breach of fiduciary duty between spouses. There is no such thing. Now, had I had more than 26 hours to prepare for this hearing, I would have prepared a full-fledged motion to dismiss. But if I can just start with what Your Honor is already aware of. Mr. Heyer is in probate court. There is a court-appointed conservator.
And who is that?
I believe it is his daughter. who is sitting
Okay.
at the table.
Got it. That's what I thought.
OCGA Section 29-4-21 says, unless the court's order, a probate court order,
Thank you.
specifies that one or more of the following powers are to be retained by the ward, the appointment of a guardian shall remove from the ward the power to, subsection 7, bring or defend any action at law or equity, except an action relating to the guardianship. Mr. Heyer signed a verification. He brought this action. It is foreclosed by 29-4-21. Similarly, 29-5-21. I'm not repeating myself, says the same thing. Unless the court's order specifies that one or more of the following powers are to be retained by the ward, the appointment of a conservator shall remove from the ward the power to, subsection 5, bring or defend any action at law or equity, except in
So I need your last name.
Mandrell.
Mandrell,
Mandrell.
like Barbara.
Exactly.
Okay, Ms. Mandrell. Is Ms. Mandrell the guardian or the conservator? Because one of these two doesn't apply if she's only one of those things.
And again, I'm flying a little bit,
You're not sure.
I'm not sure. I will say in the courtroom is Luke Lanta, who is Ms. Heyer's probate court lawyer and can probably address that significantly better than I could.
Okay, I'll take it from Mr. Levy, and better yet, I could ask Ms. Mandrell since she's sitting right here. I don't mean to talk past her like she's not here, but I'd like to confine it to the lawyers. And I'm just flagging because we don't need one of these two unless Ms. Mandrell is both. Is she the guardian of Mr. Heyer or is she the conservator?
She is the emergency guardian and emergency conservator.
So she's both.
Yes.
Okay, got it. So then 521 and 421 may be in play. They say similar things. Press on.
Under OCGA Section 9-5-1, for what purposes injunctions may be issued. And you're generally familiar, you probably can repeat the whole thing, but towards the end of the statute, Your Honor, you can grant an injunction which is if there is illegal or contrary to equity and good conscience and for which no adequate remedy is provided at law. Divorce. Down the hall or downstairs. One of the 4 Fulton County Family Division judges could handle this in a divorce case. And how do I know that? Because I appear regularly. And what shows up in a divorce court? Exactly what Mr. Levy is asking for. The standing order issues if you file for divorce. The Fulton County standing order, which I've marked as Exhibit G.
If you have, can you just bring me everything at once so you don't have to keep coming up here?
This is my exercise, Your Honor.
All right. It's slowing things down though, so just bring everything up next time you come up.
Fulton County Family Division, just like every county in the state of Georgia, prohibits, in Fulton County, it's paragraph 5, prohibits each party each party is hereby enjoined and restrained from selling, encumbering, trading, contracting to sell, or otherwise disposing or removing from Fulton County any of the property belonging to the parties except in the ordinary course of business, which, as I understand it, is exactly what the emergency motion asked for. So this action is precluded by any one of the foregoing statutes.
So I'm wondering if you're blending a few things here. The action, the complaint may suffer from some of the defects you've mentioned. Of course, other side gets 30 days to respond to ultimately what would be a written motion to dismiss. But we're here on an emergency basis, and I'm not aware of my inability to address the emergency concern to either create a status quo, get us to a status quo, maintain a status quo, while we would then work through these concerns you have. Perhaps the answer is this lawsuit would need to be refiled where Ms. Mandrell is listed as the plaintiff, as the emergency guardian and or emergency conservator of Mr. Heyer. Perhaps there needs to be a divorce filed. I think I read somewhere one of the issues that Mr. Heyer confronts is that because of the struggles he has, he isn't necessarily competent to file for divorce. And thus the standing order really wouldn't apply because he can't get into the family division except perhaps through his emergency guardian / conservator. I don't need you to respond. I'm not saying I'm right. What I'm saying is these could be compellingly correct arguments for a motion to dismiss the complaint. But today we're talking about the emergency motion to freeze things while we would then start working on the complaint. Do you answer? Do you file a motion to dismiss? What's the response to the motion to dismiss? Do I dismiss because of all the things you said? Perhaps in the meantime, we're not selling more houses and the watch collection doesn't disappear. And if $1 million is going to be spent on the credit card, there's some checks and balances if what's happening is some part of what could ultimately be the estate of the children is being depleted by someone. I'm not saying any of that has happened, or if it happened, that is nefarious. But I'm shifting focus away from the validity of the complaint. I don't vouch for the validity of the complaint to what I thought we were tackling today, which was, do we freeze things on an urgent basis while we then deal with things? So you don't have to fly by the seat of your pants saying, I don't know if she's a conservator or a guardian. I haven't had a chance to learn that yet. Fair point on your part. You learn it, and then it turns out you probably would invoke both 421 and 521. But coming in, you weren't sure, so you brought both, and I appreciate the breadth of your approach. But it seems like these are arguments for another day and not today. Your thoughts about that?
You're the judge, you're going to make the ruling. But my perception is if there isn't a legal basis for him to be here, that he have agreed, he is not, their position is he's not competent. And yet he signed a verification to a petition to get in front of your honor. He should have filed, if he's competent, to file a petition in the divorce court in front of Judge Benton, Judge Eaton, Judge Esmond Adams, or Judge Ellerby. And so fundamentally, I don't think, for lack of a better phrase, you have jurisdiction over these parties because he is prohibited from bringing this action to Judge McBurney.
What if he doesn't want a divorce? You're presuming that. Assume that the goal is not a divorce, but it is to prevent what's going on here. Why are we in the wrong place?
Because he doesn't have a cause of action recognized under Georgia law due to interspousal immunity, Robeson versus International Indemnity, 248 Georgia 306, Stanfield versus Stanfield, 187 Georgia App 722, 1988 decision. Those are the reasons. That's why in divorce court is.
Are you bringing me all the cases at once?
Both cases that I
Okay,
just cited, Your Honor.
thank you.
In Stansfield, except in extraordinary circumstances. Extreme factual situations will the appellate courts deviate from a strict application of the general rule regarding interspousal immunity. And if you look at the cases, they're all husband and wife are in car accidents, and then insurance companies invoke the interspousal tort immunity doctrine. And I think it's probably north of 99% of the cases. So Georgia still recognizes interspousal tort immunity. You can look at their motion. You can look at their memo. Not a single case between spouses giving them the authority to bring an action for breach of fiduciary duty. Instead, they cite a sentence, not a holding, a sentence out of context, I submit, that says, find it.
What's the marital harmony that you would identify existed between the hires that would allow interspousal immunity to apply here?
Neither one of them has filed for divorce.
Okay, but you practice in that field. Is that the only hallmark of lack of marital harmony, that someone files for divorce?
No, the courts have looked at in particular, the length of duration of separation. There's a case I couldn't tell you off the top of my head where they were separated for 10 years, living in far apart. And the court said, under those circumstances, that is sufficient. And I'm not, again, given the time constraint, I am not fully up on the interspousal tort immunity.
I'm not at all. I never heard of it. So I am learning about it literally for the very first time.
Doing domestic law for now 31 years, it comes up from time to time. There are extreme circumstances where it is part of a divorce case. The most common in a divorce case is spouse A gives to spouse B a sexually transmitted disease, and so there's a tort attached to the divorce case. So it's a 2-count action as opposed to just a divorce case. But there is no basis in the law outside of a divorce case to bring a lawsuit against the spouse.
Okay. Mr. Levy, we're going to have a temporary delay in getting to the merits of the TRO because I need your thoughts on Mr. Glecklin's points, about which you necessarily know anything, because and I'm not suggesting Mr. Glecklin is doing anything by ambush. He is doing everything by, I just got here, and that's different. And hopefully you've heard of interspousal immunity, so you'll be in a better position to process it.
Yes, Your Honor.
Start with that one, because some of these others, if really it was calling it a nomenclature defect is simplifying it too much. But if in truth, Ms. Mandrell could bring this very same action as guardian for Mr. Heyer, then we're going to go forward with our discussion today, because it could be refiled in 30 seconds, the very same complaint. So to me, that's one of the whack-a-mole. When we hit it, it's just going to pop right back up, whether we're talking about 29-421, 29-521. But the interspousal immunity, that to me is a more complicated situation.
Sure, Your Honor. And by the way, as far as Ms. Mandrell, in having to refile your 9/11/17, you actually could substitute.
So it's not even refiling, it's just a different
Yes.
party.
Which it brings up a bigger issue that we definitely wanted to talk about. Let me hit spousal immunity, because this is a nice introduction into this. That doctrine is actually, you mentioned talking about the harmony, but also there's a reason it comes up in this insurance cases, because it was designed to protect against collusive behavior so that the insurance company wouldn't end up on the hook for something that the husband and wife were sort of cooking up. That's the public policy behind it. That's what that is about. We submit that that is those kinds of issues. It's exactly why equitable remedy is called for in this situation. As we attach to the petition, we have the orders from the court, the probate court, where Mr. Heyer, because of his decline in health, in his mental state, and all the other things we mentioned, felt the need, well, his children felt the need to file that petition, and it has been imposed upon him, and it was designed because of the neglect and the danger, the situation, the danger to his health and his finances that he found himself in. Now, the problem here is that Mr. Heyer is in limbo. He is that man that is where there is truly not a legal remedy. And that is why and where equity comes into play, where under 21(3), and it's just, this is the idea of equity, where it finds those areas where the law can't grant the relief. Now, we're not in the probate court. We're avoiding that. We're not in divorce court because, as we understand it, we don't think that we can get there. And I want to address the question of, again, why Mr. Heyer was filing this action.
Why can you not get into the family division?
We don't think, well, one is that Ms. Mandrell doesn't have that authority to do that. Certainly not on the grounds of a marriage that's irretrievably broken. That is one that is off limits to her as the conservator, other as a guardian and emergency guardian in particular also. So she can't get there for that grounds of a divorce.
So someone who's married and gradually slides into a state of not being legally competent couldn't ever get divorced under Georgia law?
No, however, in the statute, someone in that capacity, if there was probate testimony and they had been confined to an institution for, I think it's like either 1 or 2 years. It's very drastic in that. Otherwise, they say that it's a personal right and that the courts have not given that right to certainly not to the emergency guardian, but not also to the permanent guardian. They can do it on some other grounds like that, but they can't do the irretrievably broken. They would have to establish it some other fashion. And as far as I can, I'm also somewhat new to the situation, but it does not appear to me that any of those other grounds were open for her to pursue a divorce.
Her meaning Ms. Mandrell as the emergency guardian.
Right. Now, in terms of,
Could there be, there's this power of attorney where you tell, if I have a guardian, I want you to pull the plug. If the doctors say that I don't have a chance to recover, I empower you to make a very personal decision for me. Do people write into documents like that to say, I also empower my guardian to pursue a divorce if you think that's in my best interest? I've never heard of that, but again, I don't move in your family division sphere.
I can't say that I'm moving in that family division either, but I am not aware of people doing that. And I don't know that it would be enforceable against the other spouse's objections.
Okay, and regardless, it didn't happen here. There is no such, the prenup doesn't say that. There's not any document that Mr. Heyer has executed that said, should I ever find myself in this situation, I empower my guardian to make relationship decisions for me.
Right. And Mr. Blackman is right that if we were able to file in the divorce, then there would be this.
Paragraph 5.
Yeah. And that would solve, but we don't think we can get there. And that's why we're here. We can't get injunctions from the probate court. And that's why we're only asking, we're not asking to stop the entire world. It's that, as you mentioned, there is a house, and actually Mr. Heyer's name was not on the deed. That's a story for another day. But there was property of his that was there. And probably,
So Mr. Glecklin mentioned several times that your client verified the complaint. If he's able to do that, why can't he file for divorce?
I'll answer it this way. In the probate proceedings, the probate court appoints an attorney for the ward. And that attorney has to speak on behalf of, and still is able to communicate with the ward and to respond. And from that, and if you look at the probate, the appointment of someone in that, the emergency or a permanent guardianship, doesn't take away their capacity to make a will, doesn't take away their capacity to do everything. And in fact, the public policy is to try and limit it to as much as possible. Take that, and also take under the state bar rules, the obligations of an attorney towards someone with diminished capacity that says you are to act on their behalf to protect them in an emergency. That's what we're dealing with here is only, and it's only because of this emergency situation that we feel that Mr. Tyra had the ability, the capacity to express his desire as to this. He wouldn't have it over something that's ordinary course of business, wouldn't have that kind of capacity. And I know that seems, how could you have it one way or not the other?
It does.
And that is exactly the problem where we find ourselves not having a remedy anywhere else but to seek equity and to come before this court. And if at all, if it's simply a question of if you feel like Mr. Hyde should not have been the one to commence this, then yes, Mintrell is here and can be substituted in, and we can proceed with her.
Are you the lawyer who was appointed by probate court?
No, Your Honor. However, we do have a statement from him.
Who was that?
This is Robert Bexley.
Any particular reason why you don't speak for Mr. Bexley, but why he wouldn't have provided the verification? I am the lawyer for the ward and he's not able to verify something, but that doesn't mean this is unverifiable. Based on what I know from the ward, I, Robert Bexley, provide this verification. And that's something that Mr. Glecklin could pick at, saying it's not verified by the plaintiff, but then you'd be in a position to say, well, it couldn't, I mean, because there are concerns about Mr. Heyer's competence, then we got the lawyer that was appointed by probate court to handle the verification.
And I do have a statement which has been, is under oath, notarized by that attorney. And
For the record, I would object to you reviewing an affidavit of such a critical importance, but I understand the emergency nature of today.
Okay, I'm going to review it. Okay, thank you. One of the things you've said is that there is not a legal remedy here. Apart from the personal property that has personal or sentimental value. So let's take the house and the 7 million, say 7 million round figure. Why wouldn't at a future date, Mr. Heyer, through a guardian, through an attorney appointed by probate court, be able to demand an accounting to make sure that those proceeds, which I assume are marital property, are equitably divided? That doesn't need to happen now. It doesn't seem like. In other words, there'd be a way to claw that back or to get a judgment against, I guess it would be the former Mrs. Heyer if we think that there's interspousal immunity. Again, I'm going to need to read about it, but I can't believe there's not a way to go after your spouse if that spouse is stealing that situation. I'm not saying that's what happened here, but it seems like apart from the things that are irreplaceable, there is a legal remedy. It's not as immediate, but records are records. And you can see here was the Fidelity account into which Mr. Heyer put millions and millions because he was a successful business person. And now it's $500,000. And where that went is all knowable. Maybe not right now, but knowable through due process. And that seems like not the scenario that you get equitable relief or we freeze something.
Your Honor, and certainly all of that, as far as the accounting can be done. The problem that I always have is that unless it is preserved, we will have a nice paper trail of, we can see exactly where the money went, and then it was spent here, spent there, and it's dissipated, it's gone. And I can get, yes, you say we can get a judgment, and that's a nice piece of paper, but in the meantime, there was that money that, where there's a claim to at least to be preserved. That's how I would answer that.
Okay. I guess it depends what it's being spent on. If it's being spent on consumables, it's a whole lot of Ritz crackers. You don't get those back. But if it's buying a fancy car and a home in Florida, then there are things that can be attached and a way to recoup for that. But
Constructive trust to be put over that and you put in place all of that. But right now, we're in the dark. We don't know. That's the whole point of what we're here.
so distill for me, if you were to get the relief you're seeking, it would be what? It would be, please return the particular personal items and lock down this account at Synovus Bank, or what is if you got everything you were looking for, what does that order say?
I've got it right here, Your Honor, which I'm happy to submit to you.
No, not yet. I just want to know, because the more it's, hey, we think there's $1 million in this bank account and we want you to freeze it, that is more in the space of, well, if you know it's $1 million, you can pursue that in non-emergency ways. But if it is a collection of watches that are unique, if those are sold, you don't necessarily get those back, and that's different. So I skimmed this in the way that Mr. Glecklin had to skim it to just be ready enough for today. So if you could articulate the specifics of the relief you're seeking.
Yes, Your Honor, we would ask that Ms. Ayers be ordered to take immediate steps to protect and preserve any personal property that's still present at or was removed from 20 Valley Road Northwest. That's the home that was sold. There's also 45 Sutton Place South, New York, which was an apartment that has been sold some time ago, but we believe the personal property has been under her control. There is 1091 Falling Creek Drive, Greensboro, and 185 White Pine Canyon Road, Park City. These are just locations where personal property has been located. Then we'd ask that she identify the location of the personal property, allow us or arrange for us to be able to inspect the locations of the personal property, allow us to remove any items that the parties agree belongs to the plaintiff, and then preserve property that's disputed. And if it's anything there, again, where we have no argument that it's hers, that's fine. And then we ask for, just get the closing statement from that sale and then to hold its proceeds for the duration of the order.
And when you say sale, the sale of Valley Road,
Yes.
not the New York property or the Park City. So a lot of that sounded like you were describing how to divide up the marital estate in a divorce. And so I'm circling back to, shouldn't you be in front of one of the Fantastic Four, our family division judges? I guess your answer is we can't, because who is going to challenge if Ms. Mandrell or Mr. Bexley, at Mr. Heyer's direction, files a divorce lawsuit where he is named as the, do you call it plaintiff or petitioner in a divorce case?
Petitioner in Fulton County.
Petitioner. Is that different from other counties?
And the other counties still keep plaintiff and defendant. Fulton County thought petitioner and respondent was less adversarial.
Yeah, defendant seems kind of rough in a divorce, but either way.
Oh, sorry.
Why not pursue that? Who is going to challenge that? Mr. Heyer's kids won't challenge that. I think from what you're sharing with me, they would be happy to get their father out of that relationship. And so I guess Ms. Heyer could say, you aren't competent to sue for divorce. And if she said that, then we would in fact be in a point where I don't think you could claim interspousal immunity, but you can't divorce me. She would have painted herself into a box that leads back to here.
Well, that's right, Your Honor, in terms of, I would think it certainly would be her objection as to how the divorce is being filed. The other, then, within that, once a divorce is filed, at some point, there will be a prenup that will be construed. And again, in the hypothetical that you posed for me, were someone else to commence that divorce and were the prenup to be upheld as is written, then Mr. Heyer would immediately owe $8 million to Mrs. Heyer. That's my understanding of it, again, if that prenup was found to be valid in the divorce.
Okay. So are you raising that as a reason why, well, he really does want to get divorced, but financially it's not a good thing, so he's not going to pursue a divorce. He may have that option. We don't want to go there because it's going to cost him a lot of money. So we're trying to fit a little bit of a round peg into a square hole of we're going through the civil courts rather than, I understand, no one's saying it should be in probate, but there is a voice saying this is a divorce action that is masquerading as a civil lawsuit, which it shouldn't be able to because of interspousal immunity, and we ought to be in the family division. But maybe it's not so much he's not competent, it's $8 million is a lot of money. Although conveniently, the house that was just sold, $7 million, you're getting close to just like, you know what, you keep the Valley Road proceeds, we'll call it a wash, give me my stuff back, and you're on your way. I'm getting ready for the family division.
We look forward to having you.
Yeah.
And maybe that is the way ultimately they would get worked out somehow. You asked me who would be objecting to
It sounds like your client would be objecting, but the self-objection isn't a reason to not be in the family division, if that's where claims like these should be sussed out.
well, and then we come back to who actually, whether they have the authority to file that divorce on his behalf, which sort of brings us back to where we were.
Right, except that where we are is a lawsuit that Mr. Heyer brought and verified. So he had the capacity to do that, but when it comes to confronting the $8 million prenup payment, he doesn't have the capacity to file for a divorce. They don't square real well. I'm not trying to make light of anything, but this was his lawsuit that he verified, and everyone is okay with that. But then the notion that he would have the capacity to press forward with a divorce, nope, he couldn't do that. And then I appreciate your candor in flagging, because if Mr. Gleckland didn't know about it yet, once he learned about it, he would drive that bus over you and reverse and over you again. Here's why they don't want to get into the family division. But I'm trying to balance those two, that he got himself here. I appreciate he has an emergency guardian who is seated right next to him, but she didn't file the lawsuit. He did. And yet he wasn't able to, it really is just two doors down, Judge Ellerby. If that was the draw of the four, you'd be there. Being able to make these same arguments, and better yet, paragraph 5 would kick in. and you'd have this automatic freeze of things.
Yeah, the best I can tell you is that because of the complexities of a divorce and all of the financial decisions that have to be made, then that is the kind of area that does fall where I don't think he has that capacity to make that in terms of asking for, just someone to hold on to his stuff. He can express that concern, and that's all I'm trying to act on and carry out that, and we're not seeking any one of those other remedies because of those issues.
Okay. The closing statement from the Valley Road, what does that tell you? Is it how much did it net? Is it who bought it? I don't know how in the dark Mrs. Heyer kept Mr. Heyer and the stepkids, her stepkids. What's the significance of the closing statement?
It is, again, and there may not be anything of value on that, but in terms of trying to figure out, okay, at the end of paying off title person, this and that, what was the net? And oftentimes it will indicate, if it's being wired, if there are wire instructions or something like that, give us an idea. But again, if there is disclosure without it, no, we don't need it.
Okay.
We've been sort of in the mushroom department, if you know what I mean. We've been kept in the dark and fed stuff, but.
Okay. Got it. All right, Mr. Glecklin, you have listened patiently as Mr. Levy helped me better understand why he and his client have picked this vehicle to pursue what strike me as very legitimate and understandable concerns. And frankly, I'm interested in what we can do to get some temporary relief in terms of the personal property. The closing statement is always going to be out there. And so that's learnable in lots of different ways. But what about, am I correct? And I don't mean to keep bringing up watches. One of the items of value was a collection of watches.
Yeah, sure.
Okay, good. I'm going to keep using that as an example because I don't wear a wristwatch, but I know for some people, they're very significant. I know they can be very expensive. So, hey, I need to know where my watches are. And Judge, I don't know how to do it. I'm basically shut out. And so I need you to order relief such that we figure out where the watches are and they don't move from where they are right now, other than they might move to where Mr. Heyer is now. And then we remove one burr from underneath the saddle.
I think you now, Your Honor, 45 minutes into the hearing, have not quite the full picture, because I still want to walk up to you at least one more time. But you've got a good sense of the picture. Every single family that is about to go through a divorce is going to come running to Judge McBurney for a TRO. She took my watch. She took my car. She took my artwork. She took my gardening tools. You're about to open the floodgates like you cannot believe. I don't really want a divorce, but I want my stuff back. Now, I am well aware of what their prenup and their amendment to prenup says. And if you look at 22 of the petition, Mr. Levy is aware. If my client files, she gets 5.5 million. If Mr. Heyer files, she gets 8 million. It's a $2.5 million reason to be in your courtroom, because you've said it, I'll say it 5 more times. He was good enough to verify the petition to get in front of Judge McBurney, but not Ellerby or Benton or Eaton or Esmond Adams. That, you nailed it. That's it. But here are the things that you haven't been told.
Before we go, it's bother me. Hold on.
Okay, thank you. I'm handing you what I've marked as exhibits C, D, E, and F.
These are all things Mr. Levy's seen. He's not about to jump out of his chair saying, what are these? No. Okay.
I just handed them to him. I know for a certainty, Dennis Collar, Mr. Heyer's divorce lawyer, because Mr. Collar, his letter to me was attached by Mr. Levy. So certainly there's been communications between them. I've been dealing with Mr. Collar for months on the Heyer matter. Mr. Collar is out of the country. I just know because I have 3 cases with Mr. Collar. So perhaps that's why he's not here and could fill Your Honor in. But the other legal issue, Your Honor, the suggestion that Mr. Levy made that, oh, you know, we could just change and just add Ms. Mandrell. No, Your Honor, cannot. She does not have authority to file this lawsuit. Her letters of emergency guardianship and conservatorship do
Is
not.
that what you handed me, or
No.
you're gonna get to this
Well, I
stuff?
saw you, yeah. What is missing? The house is hers. The house is hers. He deeded it to her. He then, as Exhibit C says, upon the execution of the deed, I freely acknowledge that effective upon the execution of the deed transferring title into Mona's name, the residence shall constitute Mona's separate property. You use the example of, hey, equitable division, we'll ferret it out. It's hers. They want to freeze her money.
She could burn it down if she wanted to burn it down.
Absolutely. Absolutely.
Okay,
That's Exhibit C. Exhibit D, he says it again. And moreover, in Exhibit D,
how does he give it to her twice?
well, this is what he signed last year or 2 years ago in 2024. The property in the, essentially everything in the house, except for those items listed as his separate property in the prenup, is hers. What are we doing here? What are we doing in front of Judge McBurney?
You're educating me a lot about family law. I'll be in there someday.
Look forward to it, and I mean that sincerely. These are the things that were not disclosed in the petition. These are the items that are just now being brought to the court's attention. These are hers by his agreement over and over again. His children may not like it, but he did it.
Do you have or is it somewhere in the record already, the list of items in the prenuptial agreement that Mr. Heyer basically excluded from Valley Drive is yours. I'm gonna live there with you, but it's yours. And I'm reading this. If we buy furniture, it's yours. It's a gift from me to you. That really fancy sofa, that's yours. But you're saying there are a few things that aren't, and you don't need to hand it to me now. Is it in the record, or you'll need to get
It is in the
it?
record. It is, I'm not sure what exhibits that they attached, but it's the original prenup and then the amendment to the prenup. Essentially, it's the artwork, which if you also see, and I think there was reference to it, that Mr. Heyer had movers, we coordinated, Mr. Collard and I coordinated to have the movers come and pick up the artwork. Now, like 99.99% of divorce cases, he still says, yeah, I got most of my artwork, but there are 8 other pieces that I think are mine. And her answer is, no, those aren't yours. Those are mine. I had standard, he said, she said. But yet they want to have your honor enter a TRO prohibiting her. Now, you want to talk about the 8 items? You can be sure I've had a conversation with my client. They're coming after those 8 items. I know you got your defenses. Just make sure they don't go missing. I got it. Same thing. He wants to claim watches. Well, we're about to hear, well, he lived in, you heard the houses. There's New York, there's Park City. Well, and now they're going to say, no. Mona had them. It's all her. Bring it to divorce court. We can have that battle about what Judge Bedford used to call the potted plants arguments. We'll do that, but not here. Who has what piece of furniture? I don't have it. I lost it. You had it last. That's why we went to law school, to become family lawyers, to argue over missing items of personality. That's where the argument should be, down the hall or downstairs. None of these items that he is asking for, other than those 8 pieces of artwork, and for the sake of this discussion, include the watches. I'm not even sure the watches were listed. They may be. I'm not looking at the list. That's standard divorce stuff. And as Your Honor said, paragraph 5 will kick in. If that stuff goes missing, she's going to have to answer to it. We're in the wrong courtroom. We're in the wrong situation.
Okay.
It's 2.5 million reasons that we're here.
Mr. Levy, the one thing that Mr. Glecklin mentioned that I need you to help me better understand is Mr. Collar.
Okay. Yeah, he is someone.
I know who he is.
Yes, I do.
What is being, that says to me that there are active conversations about doing the thing you say can't happen or isn't able to happen. I don't know the last time Mr. Collar and Mr. Glecklin spoke, but it didn't sound like it was 6 years ago.
No, but the problem, Your Honor, is in the midst of those conversations, there was a huge sea change where the house, where even if you take its ownership off the table, the contents that are in there, we're told, oh, the house is sold. Everything must go. And doesn't matter. Time's up. And we weren't even told it wasn't marketed. There was nothing. They either said, okay, you're gonna.
They don't do a lot of marketing of houses on Valley Road. They don't have the for sale sign out front. They just get sold and you read about it in the Buckhead newspaper.
Yeah, but a different zip code.
Same.
Away from that. But anyway, Your Honor, that was, problem was that all of a sudden there was an emergency created by Ms. Heyer where the house is going away. So if there was anything there, then it had to be taken or it was going to get thrown out or who knows what. We had limited access.
Yep.
And that was the idea, was simply what's the in-between point to just pause everything while if those conversations can continue between Mr. Glecklin and Mr. Collar. Wonderful.
Are we not too late, though? I thought that the get out date or get your stuff date was the 3rd, and we're on the 9th. What is, do you know if you and I went to 70 Valley Road, we're allowed in, 20 Valley Road, with the big boxes that say Steve on the side, or you don't know? That's the problem, is you don't know. They could be in a storage unit somewhere. There's the Steve and the Mona storage unit.
Exactly, Your Honor. Everything may very well be all tidied up. So if the house goes, I don't know what's in there. Again, it could all have been moved out and it could be, as we talk, it could all be safely preserved. And all of this
Right.
is for naught, except we can't get any other answer. And so it's like, what else can we do?
It seems like a Collar Glecklin conversation. I mean, hey, where's my client's stuff? Because Glecklin would say, hey, my client sold the place because it was hers. And 99% of what was in there was hers because your client said it was a gift to her. And then Collar would say, yeah, but not the watches and not the hunting rifles or the artwork or whatever is carved out. But that seems like a Collar Glecklin back and forth. And then the judge sees the emails like, you shouldn't call each other those names. And we work through it. But it's not we work through it. It is where Collar and Glecklin ply their trade.
So here's the X factor to that, though, is as we put in statements, we had a statement from the doctor who had, one of the doctors who had diagnosed Mr. Heyer, is he has a progressive condition. It certainly manifested in 2019 and has been progressing steadily. And so while there are documents that has his signature, circumstances under which they were signed is certainly, let's just say, up for debate.
Sure.
At least we have a debate.
Does that get sorted out in the family division or in probate court? The capacity to execute some of these documents. I don't know how that goes, because it seems like it's a intersection of the two courts. But it's much more efficient to have one judge, assuming she has jurisdiction, to resolve both those things. Yes, you had the capacity to execute the gift of anything in the house is Mona's. It's my gift to you, other than the prenuptial items. But if there is a legitimate basis to say, you know what, yes, that's his signature, but we don't think he understood what that document said. And you challenge that. Does that get challenged? Do you do divorce cases?
I try not to, Your Honor. I have some,
Okay.
very little. And again, my firm often gets called in when there is a business that is involved in it. So that's also sort of how we get enmeshed in it. But
Right.
certainly not as Mr. Blackman in his, specialized in it in his years of experience there. I would not,
Right, his strange choice of a trade.
It found me, Your Honor, and the answer to your question is divorce court. Because as I understand probate court, they're determining capacity at this point in time, not backwards.
Okay.
If Mr. Heyer, for instance, is going to challenge the prenup, the amendment, I didn't have capacity back then, and then he's obviously going to have to put up whatever witnesses, and Mr. Collard will be a witness, because Mr. Collard did the prenup, Mr. Collard did the amendment to the postnup,
Right.
and to your point, the Gleckland Collard conversations, I'm getting my steps in, Exhibit I.
Well,
And just like that, a $7 million mansion becomes the center of a courtroom storm. The judge now has to decide whether this was a legitimate financial decision or a shocking move made without the husband's knowledge. When millions of dollars and family power struggles collide, the truth always finds its way into the courtroom. What do you think? Was the wife legally allowed to sell the mansion, or did she cross a serious line? Let us know your thoughts in the comments below.